Hey guys, it's Laura from TheRealLauraB. I'm back with some late breaking news. Elaine Bredehoft decided to leak another filing last night at the end of the business day. Was this a PR move? Yes, I think it was. And I thought I'd put my quick takes on it. And well, let's get started. Hi, I'm Laura, also known as TheRealLauraB from Twitter. I'm a researcher, truth seeker, and a new wave internet journalist. I'm not a lawyer, nor offering any legal advice. Join me on a journey to draw the curtain back to expose key news developments in the world of celebrity lawsuits and current events. Let's get started. Welcome back. Well, this has been an interesting week. We've had not one, but two leaked documents by Amber Heard's defense, Elaine Bredehoft. And I mean leaked. They've not been uploaded to the Fairfax County website. In fact, let's do a little recap. We had people who were at the hearing for the when the verdict was being signed on June 24th. Elaine tried to file some motions, and Judge Ascarati said, no, this is signing day. We are done. There are no more motions. You can lodge your objections, which Mr. Depp, bench, you did lodge for Johnny. Any objections to the case that you could register them in case you were going to do an appeal. But no, there's not going to be any more motions. There's not going to be any more hearings. There's not going to be any rulings. Judge Ascarati said, I'm done. I'm signing this verdict. And Elaine was like, no. You don't have to sign today. We can do this. And Elaine's like, because Elaine was trying to buy more time. She thought, well, if I can get this motion filed, then this hearing, Depp's team has to file, respond. I could delay the judgment by a couple weeks because in her mind, my client doesn't have the money to put up for bond for an appeal. So let me just delay. And Judge Ascarati said, no more motions. I'm done with this case. Finito. I am signing the verdict. After this, you can go to appeal. You can put up your bonds. She signed the verdict for the $10,350,000 against Amber Heard, and she signed the verdict $2 million against Johnny. Now, I guess they have to negotiate on their own if they're going to net it out. Otherwise, they're both going to have to pay each other or put up a bond to appeal against each other. But that's where that was left. Then we had another filing, an early filing by Elaine. Let's take a look at this so people don't forget this. Elaine filed this on May 18th. This matter came to be heard upon defendant and counterclaim plaintiff Amber Laura Heard. So this is Amber's side. This is Elaine filing it. A motion to seal records relating to jurors' identities filed on May 16th. And upon consideration of the briefs and argument of counsel, it is hereby ordered that Ms. Heard's motion is granted, and it is further ordered that the names of all jurors shall remain sealed for 1 full year following the conclusion of the trial in this matter. So ordered. So I think that's important. Now, we all assumed, rightfully so, that this is a normal thing they do. And it could well be. There could be nothing nefarious about this. But I think it puts things in a strange light, honestly. And let's see what you think. So let's take a look at the calendar. I think that's where we need to go first, just to remind ourselves of a sequence of events that have been going on here. So here we have this year's calendar. April 11th was when this trial officially started, and it started with selecting the jurors, voir dire. My understanding is, and we'll follow some of these codes, that both sides were given the list of the jurors, names, age, address, and employment 72 hours before the trial. Now, I don't know whether they count the weekend, but they would have had that information, and as good lawyers do, they would have poured through that and right away said, oh, wait, this guy's a lawyer, or this one's an EMT nurse, or these should even be in the pool for our case. So they went through and they checked out the question, they checked out everything. And they didn't find anything wrong. Or if they did, it was behind the scenes and we don't know it. So they brought in, I think there were 50 jurors, if I remember, that were going to be part of their group that they were going to be able to pull from. And Jax and I sat in that exterior courtroom, I guess you call it, the overflow room, on these hard benches, craning our neck to watch the TV, to watch voir dire. We watched them pick the jury. And it was really interesting, but it was long and boring. But some of it was really interesting. And they did exclude some people. And then at the end, both sides had a right to just cross off any 3 people they wanted to do. And by the end of the day, they had a jury. And So the case began, and we went for weeks and weeks and weeks and weeks. And then we had a week off because Judge Ascarati had a judicial conference she had to attend to. And we all saw when they came back that Amber Heard seemed to be correcting her testimony a bit. But let's sit back again and remember what we saw in the courtroom. Johnny Depp had a lot of lawyers. They weren't all asking questions at the time. It was one-on-one. Same with Amber Heard's side. When the lawyers weren't asking questions, they were listening intently to questions and answers, the testimony, but they were also watching the jury. Their role is to really watch the jury for their reactions. Are they interested? Are they bored? Should we change our strategy? So their eyes are on the jury. And what I found interesting is a lot of the YouTube lawyers I met who were trying to get in there, who could have sat home and watched it on TV, they wanted to be there to watch the jury's reaction. So this is very typical of a lawyer. So they saw those jurors all day long, every day. If they had ever concerned like, ooh, that guy looks a little bit young, they could have raised it at any point. But they never did. When I say they could have, that doesn't mean anything would have been done about it. We'll get to that. But they never did. During the week off, you would have thought they strategized, and I'm sure they did. And again, did something come up with about that juror? Maybe it did. Maybe it did, and it's something they kept in their back pocket because they didn't file to have the juror's name sealed until after that week. Maybe they did recognize something, and they just wanted to file it away in case they lost. The trial completed on the 27th, and the jury received the case to go back and decide it. Ben Chu realized something was amiss. He didn't like what had happened in the closing argument. So he said, hey, wait, hold on. Wait a minute. They shouldn't have said that stuff in their closing argument. And I remember the judge sitting there in court and saying, I hear you, but I'm ignoring you. I don't mean to ignore you, but I am ignoring you. It's too late. The jury has the case now. Whatever motion you filed, it's too late to object. You should have done this beforehand. The jury's gone. They have the case. And she said, I'm ignoring your motion. Done deal. It eventually went up on the website, but it was over and done with. So we finally get our verdict against Amber Heard. And what happens? She goes there on June 24th. We get the verdict, but on June 24th, Judge Ascarati sets the date when the verdict's going to be signed. Amber's side files nothing. They show up that day at court as, like I said, like, oh, here's these motions I want to do. And Judge Ascarati says, no, I am done. So what does she do? She waits until July 1st to start making filings. And she files them on a Friday at the end of the day, this time before a holiday weekend, knowing that the PR-wise, it would stir up a lot of issues. And then she did the same thing the following Friday, filed another motion just to rile up the public, not to give Mr. Chu a chance to answer, or maybe he has no intention of answering. Maybe Judge Ascarati has no intention of answering. But that's what you have when you take a quick look at the calendar. It kind of reminds you that how much time she had to possibly do something. Not that she could legally, because we find out later there's more to this. She does file. Let's see, what else did I want to cover first? I do want to cover one thing that I reached out. I was like, wait, this filing went up. Why are we not seeing it? So I reached out to a source I had, Fairfax Courthouse, and they said, per Chief Judge Ascarati, nothing else will be uploaded on the public website regarding the trial. If people or entities want copies of any post-trial motions, they'll need to obtain them from the clerk's office. So that's done. She's finished. Nothing's going to be uploaded. And I heard a lot of lawyers doing their commentary on YouTube saying that they're waiting for it to be uploaded. Nothing's going to be uploaded. It's done. Elaine Bredehoft knew that, and she leaked it to the public. So what's the first one she leaked? And I'm not going to read the whole thing. I'm only interested in the section about her part about the juror. So let's see if I can find that one. Oh, here we go. I'll try not to have to edit this. So she brought attention. She says, Judge, I want this entire thing thrown out. There's so many mistakes here, which is meanly saying, Judge Ascarati, you made so many mistakes here. But they're saying they were awarded too much money. They overlooked the definition by innuendo that was miscarried out. Judge Ascarati ruled on all of this. But the last thing she threw out was, oh, by the way, something looks funky with this juror. Juror 15 seems to be a lot younger than he should have been. The court should investigate whether Juror 15 properly served on the jury. On the juror panel list sent to the counsel before voir dire, they had this list, court noted that the individual who would later be designated as Juror 15 had a birth year of 1945. Juror 15, however, was clearly born later than 1945. Why clearly, Elaine? Because you sat in that court for 6 weeks, your whole team did, and you saw it. You saw that there was something up here, and you didn't say anything. And I think that's my takeaway why you filed to have this list confidential, because I think you stuck it in your back pocket just in case you needed it. And I don't know what any kind of rules are on that. So clearly he was born later than 1945. So they have this public information, but what's important is she tells on herself, because I think this was like really just meant for public consumption. It was really meant just to rile everybody else up, because I think she knew there was no law precedent that they could do anything about this. Ms. Heard recognizes that Virginia Code 8.01-353 states that any error in the information shown on the jury panel shall not be grounds for a mistrial or assignable as error on appeal. The footnote continues on the next page. And the parties in the case shall be responsible for verifying the accuracy of such information. She's telling on herself. But the apparent error in the jury information form relating to June 15th is not the basis for Ms. Heard's concerns. It is the potential that Juror 15 was not, in fact, the same individual that the court assigned as Juror 15, and or was not verified by the court's clerk's office as required by Virginia Code. This would warrant setting aside the verdict and ordering a new trial. No, Elaine, even as a non-lawyer, I can read. It clearly says the parties in the case shall be responsible, that the information is correct, that this is not grounds for mistrial or assignable as error on appeal. So she's trying to pull the wool over her eyes. And this is not unusual for Elaine. And this is where maybe my followers have more information than some of the law tubers, who are fabulous, but came into this case wanting to come in fresh headed, if you will, like a juror, and only take in what the jurors were getting. But we've been reading Elaine's motions for years. Well, yeah, for years. She's been there for years. There's been lots of lawyers before her. And she blatantly misrepresents information. So when you read these motions, you have to remember that. And the most egregious one that we all can relate to and remember, she wrote in her motion and stood in that courtroom to Judge Ascarati and said, Amber Heard could not donate because Johnny Depp sued her and she needed the money for her legal fees. Blatant lie. She had all the money 13 months before she even wrote the op-ed. There was no legal issue that was happening to cause her from having to donate. None. So that was a blatant lie. So you have to remember these things, that Elaine is going to put in there what she wants the judge to believe, and hopefully what Ben can't dispute. She knows that was bald-faced lie. And we've heard this before. So then it was, well, she pledged it. So that was their new thing. They pledged it. No, Elaine. No, Elaine. So let's see what she has to say in this one now. Or let's see what the law says. I did pull that up. All right, let's see. And it's pretty simple. Prior to the jury being sworn, objections to irregularities prior to the jury being sworn. There you go. The following objections may be made without leave of court. Now, Elaine's going to cite, hey, I wasn't allowed to ask these questions. We were given questions beforehand that I had to stick to, but it clearly says without leave of court. She didn't need permission to raise this. An objection specifically pointing out the irregularity of any list or list of jurors made by the clerk from names drawn from the jury box or in the drawing, summoning, returning, or impaneling of the jurors. Unless objections to such irregularity or disability is made pursuant to subsection A, prior to the jury being sworn, unless it appears that it was intentional or probable cause of ingestion of a criminal case, it's not a criminal case, or the accused in the civil case of the party making the objection, such irregularity or disability shall not be cause for summoning a new panel of jury or for setting aside a verdict or granting a new trial. There's the rule. She cites it herself. That's how I found it so easily. She cites it herself. And then on the next rule that she also cited, let's take a quick look at that, because we're going to be legal eagles today. Civil remedies and procedures. Again, upon requested, the clerk or sheriff or other officer responsible for notifying jurors to appear in court for the trial of a case shall make available to all counsel of record in that case a copy of the jury panel to be used for the trial of the case at least 3 full business days. Now, business days, we have that answer now. The jury was selected on a Monday, so they had Wednesday, Thursday, and Friday at least before the trial. Such copy of the jury panels shall show the name, age, address, occupation, and employer. So they could look for any possibilities of an issue that they wouldn't want that juror picked. I would imagine in this case, they wouldn't want, say, like I said before, an EMT nurse that could tell that Amber was lying about these injuries after these horrific incidents, or a psychologist, for example. Such copy shall have name, address, and employer of each person in the panel. Any error in the information shown on such copy of the jury panel shall not be grounds for a mistrial or assignable error on appeal. And she quoted this in her first motion. And the parties in the case shall be responsible, the parties, not the county clerk office or the judge, for verifying the accuracy of such information. So there it is. So what does she do? Again, now she knows nothing's being put on the court case. She knows nothing's public. It's only who she chooses to leak to. The first one she leaked to Courthouse News. That was like some 60 pages, I think. And a lot of it was a lot of other legal stuff. And then she stuck that juror thing in the bottom, which was the most tasty for the public who were not into the legal part. And we just saw that with Ghislaine Maxwell, that they had a juror who apparently lied about their past experience with abuse, but they didn't overturn that. They didn't declare a mistrial on that. And that was a criminal case. So what does she do? She leaks again on a Friday. And she does it in such an egregious way to make sure, let's see if I can get this, to make sure it's going to get the most attention. And she does it with Deadline. And we know Deadline has been biased against Johnny for many, many years. They did horrific coverage. And right away, what do they start off with? These big headlines. Johnny Depp verdict thrown into chaos as wrong juror seated in Virginia trial. Amber Heard says wants new trial. Well, actually, she doesn't even want the new trial. She just wants the whole thing thrown away. But declare mistrial, I want a new trial. And they do it in the most salacious way. And of course, so many other of the legacy media picked this up, similar titles, to scare the public, to scare people. And that's all it was. It's a PR grab. That's all this is. This motion's not going anywhere, in my opinion. It was strictly a PR grab. There wasn't enough drama swirling around Johnny Depp's win over Amber Heard in his multi-million-dollar defamation suit last month. Things have turned judicially weird. Ms. Heard had a right to rely on the basic protection as prescribed by the Virginia Code that the jurors in this trial will be individuals who were actually summoned for jury duty, says a partially redacted new filing, which we're going to take a quick look at. Now, yeah, she was relying on her lawyers to protect her. Not the county clerk, not the judge, her lawyers. I'm not going to read the whole article. I think her redacted motion, that deadline provided has enough information in it for us, and we can save some time. We'll go right to that. Filed Friday, end of business day, to rile up the news. Supplemental. Let me zoom in a little bit on this for us. Supplemental memorandum in support of Section 7 of the defendant and counterclaim plaintiff Amber Heard's post-trial motions based on additional discovered facts. Now, remember, we just read the footnotes of that. So she admits in her own footnotes, like, yeah, I know we can't really do anything about it. The problem was ours, but I'm going to file this anyway. That's why I think she knows it's dead in the water. She's filing it for the public. This is pure PR. Defendant and counterclaim plaintiff Amber Laura Heard hereby supplements, as we just said, her post-trial motion, which Judge Ascarati said she was not entertaining any post-trial motions, based on newly discovered facts and information that juror number 15 was not the individual summoned for jury duty on April 11, 2022, and therefore was not part of the jury panel and could not have properly served on the jury at this trial. Therefore, a mistrial should be declared and a new trial ordered. Not going to happen. Virginia law provides that only those jurors whose names appear in the list provided under these two rules should be used for the trial of cases, civil and criminal, to be trialed during the term. This rule explains that these potential jurors are selected from a list of registered voters in Fairfax County. Quote, every year, citizens' names are randomly selected from the Virginia Supreme Court from the list of registered voters for Fairfax. I'm going to come back to that. It says every year. It doesn't say every week. It doesn't say every month. Maybe it's quarterly, but every year they collect these names, which means by the time they call that juror, they could pass away, they can move out of the area. But every year they collect these names as a possible pool for the juror. The answer book for jury service, potential jurors are selected randomly by the jury commissioners using lists designated by the court, such as voter registration lists and the driver's license list. Well, I've only seen that they used voter registration. In this case, the jury panel list included an individual named Smith with a listed birth date of something in 1945, residing at some place in Virginia. Don't know, USA, I would assume that says, or the county. This means the individual would have been 77 years old at the time of trial. They've got some attachments which they didn't include. The attached voter registration information, so they did use voter registration, lists two individuals with the last name Smith residing at the same address, appears. One with the birth date in 1945, and the same person listed on the panel list, and a birth date of 1970. Both of these individuals apparently live in the same address. Now, here's the thing about Elaine. She omits things. If there was something important to help her, she would have put this in here. For example, in my opinion, if it was John Smith and Fred Smith with two different first names, do you not think she'd be putting this in here? So I think it's safe to assume there is a John Smith Sr. and a John Smith, I'm going to say Jr. But let's quantify that. Not every father and son are senior and juniors. There could be a John C. Smith that had a different middle name and a John M. Smith that they had different middle names. They would not be senior and junior. Now, my husband's a junior, and then we had a son. My son's the third, but they don't live in the same states. And my husband kind of dropped using the junior. On some things, he tries to be formal and use it, but not in everything. He doesn't use the junior. Even if we lived in the same state, it's not really that big of an issue. These people happen to live in the same house. We can guess they could be junior and senior. We could guess that the elder lives with his son, who's 52 years old, and that any mail coming to the house he would have presumed would be to him. He opened it up. He didn't look at it. He showed up for duty. Maybe it's a junior, maybe it's a senior, maybe it's just different middle names. But I can assure you, if they were different first names, Elaine would have put that in this motion, in my opinion. The individual who appeared for jury duty with this name was obviously the younger one. Thus, the 52-year-old sitting on the jury for 6 weeks was never summoned for jury duty on April 11th and did not appear in the list as required under Virginia Code. As the court no doubt agrees, No, the court doesn't agree, Elaine. We will see. But Judge, I don't think we'll see. I don't think Judge Ascarelli is going to answer. It is deeply troubling for an individual not summoned for jury duty, nonetheless, to appear for jury duty and serve on a jury, especially in a case such as this. This was a high-profile case where the fact and date of the jury trial were highly publicized prior to and after the issuance of the jury summons. Virginia has in place statutory code provisions designed to ensure the person called for jury duty is a person arriving for jury duty. And they do the code again. Of course they do. And it says it's up to the counsel to verify if they think there's any mistakes. Oh. Especially in this case, a high-profile case. First of all, Johnny Depp and Amber Heard are not entitled to any special preference over any other civilian going to court. They're all equal under the law, number one. Number two, I was in that courthouse. There's a big television screen along walls listing all the courtrooms and all the cases. They were packed. You can imagine that all state courthouses are packed now because they're getting back into gear after the beer bug. I say beer bug so that YouTube doesn't get mad at me. Because so many cases were delayed. Once the courthouses were open again, they're packed. Every courtroom is packed. And we could see that. Sometimes the overflow room that was supposed to be allotted for 50 people from this case, the Depp case, sometimes they had to take that away because they needed it for trials. The place was packed. That means there were a lot of jurors being called that day, not necessarily for the Depp case, for a lot of cases. People would not necessarily know what case they were going to get assigned to. They came in, they were assigned a group, and that group got pulled into whatever case. So there's no way ahead of time somebody could know. And since they have the same name, she's no longer even suggesting that somebody hung out in the jury room and said, hey, I think you're going to the Depp case. Can we switch summons? Because they have the same name. So she can't even claim that anymore. Fairfax County's questionnaire webpage furthers this goal by requiring all county residents to log in using their 7-digit number, zip code, and birth date. Questionnaire. Well, I was curious about this. So let me just jump to that real quick. Let's see if I can find that. Here's the Fairfax County website. Questions about the juror questionnaire. Every year, citizens' names are randomly selected by the Virginia Supreme Court from the list of registered voters for the Fairfax area. To update your voter registration information, you can contact your local office of elections every year. Like I said, not every week, not every month. I received a questionnaire. Does this mean I will get summoned for jury duty? The questionnaire is the beginning of a screening process for prospective jurors. Not everyone who receives a questionnaire will be summoned for jury duty. The actual summon. They're not saying they won't necessarily be seated on a jury. They're saying we may not even call you to court. I think that was the most important point. So the Smith Sr., and I'm talking about senior in age, he could have completed the questionnaire months before. Doesn't say when they'll get it. They just said once a year we pick all these people and we send out questionnaires before you are summoned. Then they talk about the general things. You know, what do I do? People are out of town, things like that. One of the things is age. I am more than 70 years of age and choose not to be a juror. What should I do? If you would like to take the age exemption, you can check off question number 1 under possible exemptions found in your online form, as well as the paper form. There is a paper form. We saw people walking in with paper forms. So it doesn't seem like everybody had to check in online if you're given that option. Maybe there's somebody who doesn't have access to a computer and online. They don't have to even be 70 years old. There's a lot of people, we take it for granted that people have computers and internet, but not everybody does. So there is an online form as well as a paper form. And we saw everybody walking in carrying, I think it was a green paper form. If completing the questionnaire online, indicate your date of birth in the exemption box at the bottom of the online form. If completing by paper, you have that option, write in your date of birth in front of the form. Again, Misdirection, Elaine. Misdirection. She's very good at it. That's why I think this filing was only for public. It's just to smear Johnny, it's just a PR thing. This is the same people who, Shane, who his PR company was representing TMG, and they're putting out the coverage against Johnny. So we're very well aware of these tactics. Those safeguards are in place and relied upon by the parties to verify the identity of the correct juror to ensure due process and a fair trial for all litigants. When these safeguards are circumvented or not followed, as appears in the case here, the right to a jury trial and due process are undermined and compromised. No, not necessarily. You have to prove some nefarious intent here. If this was a simple mistake, same name, took the form, showed up, did my thing, he's still an impartial juror. You questioned him. You had the chance to match his birth date to his face when you questioned him voir dire. You were not limited to wear a blindfold, Elaine. You may have been pre-assigned questions, but as we read in the code, you're not limited to leave a court to say something's fishy here. Ms. Heard had a right to rely on the basic protection as prescribed by the Virginia Code, and the jurors in this trial would be individuals who were actually summoned by jury duty. In this case, it appears juror number 15 was not, in fact, the same individual as listed in the jury panel. Ms. Heard's due process was therefore compromised. Under these circumstances, a mistrial should be declared and a new trial ordered. For all reasons set forth above in the initial memorandum, Ms. Heard respectfully requests this court declare a mistrial due to improper jury service in violation of her due process rights and order a new trial. I don't believe her due process rights were violated. I think they still got an impartial juror. Let's jump down to the footnote. Mr. Depp would be incorrect. Would be, not is. That tells me that I don't think then she responded to her original filing. Maybe he won't, maybe he hasn't yet, but would be incorrect tells me he has not answered. Mr. Depp would be incorrect in contending Ms. Heard somehow waived this argument by not raising it during voir dire. Not only were the voir dire questions ruled on in advance and the parties limited to those questions during voir dire, but the responsibility to ensure that the potential jurors participating in voir dire are the ones listed on the jury panel rests with those individuals and the court. Due process entitles litigants such as Ms. Heard to rely on the basic assurance that potential jurors are who they say they are and are actual individuals in the court summoned. Well, again, you have to show something nefarious here. I mean, this guy probably thought he really was supposed to be there. I don't think it was anything terrible that he did, and she still got a fair trial. They still got to ask him questions. And for her to say that our questions were limited, the code clearly states you don't have to ask for leave of court to say something fishy here. Something doesn't look right. I'm not too sure about this. So let me see if there's anything else I can add to this. Well, we know Judge Ascarotti wasn't always thrilled with Elaine. She gave her a lot of leeway, maybe way too much leeway. Maybe that's why she thinks she can get away with a lot of this, because maybe Judge Ascarotti should have put her foot down a little bit more. So just because this just happened, I'm going to tag this on also. Craziness. So a story just came out, and before I get to that one, I'm going to hit this one first. This came out that poor Amber, had a glitch there, poor Amber can't pay the damages, right? The New York Post reported Amber Heard is broke due to mounting legal fees, lavish spending, sources say. Amber Heard can't pay the $10.4 million she owes Johnny Depp, her lawyer revealed Thursday. Don't forget, it's going to get 6% interest every year. Sources told the New York Post the actress is broke due to hefty legal fees associated with the bombshell defamation trial. Oh, no, absolutely not, Heard's attorney Elaine Bredehoft told NBC today when asked if the actress had the means to cover the hefty judgment handed down by the jury on Wednesday. The high-profile court battle with her ex-husband has left the 36-year-old actress hurting for cash, according to sources, including one who has placed the blame on Heard's past lavish spending, travel, clothes, gifts, and wine, whatever. Multiple sources said the Aquaman star had to switch legal representation and is relying on her homeowner's insurance policy to cover the cost of her current attorneys in the case. That's interesting. Had to switch legal representation. Well, let's just go back to that for 1 second. Amber Heard was represented by Robbie Kaplan, part of Time's Up. There was some question whether Time's Up might be funding it. I think Robbie Kaplan said no. Robbie Kaplan pulled out right after the videos were released, or the audios were released, of Amber Heard confessing to instigating physical fights. That's when she pulled out. She cited the cost of travel. She cited that with the beer bug. It was just too expensive and too difficult to be traveling to and fro New York to Fairfax. Now, most of these hearings have been WebEx, so there was no reason for that. Then shortly after, it comes out that she's opening a new office in Washington, D.C. So are they now trying to suggest that Amber Heard fired Robbie Kaplan because she couldn't afford her and went to cheaper local counsel? That's what Elaine seems to be suggesting here, or the source is suggesting. Let's go back. Multiple sources said Aquaman Star had to switch legal representation and is relying on her homeowner's insurance policy to cover the cost of her current attorneys in the case. The bill for Heard's attorney has mostly been footed by the travelers' companies under terms of actresses' insurance policy, sources said. So they're saying it's the travelers. And I was sat at the court, and we kept wondering who this woman was that kept coming in. A vice president of the insurance firm, Pamela Johnson, was spotted in the courthouse with Heard multiple times. I mean, almost every day. I don't think she missed a day. Throughout the trial, neither Johnson nor travelers returned calls to the post. So what did we also know was that Elaine announced to the jury that her legal bills were $6 million. $6 million, which she had no right to tell, but she did. So she's got this traveler's insurance that's supposed to be covering her legal fees. We've had a lot of on Twitter back and forth whether that would cover the damages. Well, lo and behold, a new article out. Let's see what they have to say. This is from the LA Times. Amber Heard faces new legal battle, this time with her insurer over the Depp suit. Amber Heard is facing legal battle on a new front, this time with her insurance company, New York Marine and General Insurance Company. Not Travelers. She's got another insurance company on the hook. Filed a lawsuit against the Aquaman actor Friday in federal court, seeking a ruling about whether it has to pay Heard after her unsuccessful defense of a defamation lawsuit brought by her ex-husband, Johnny Depp. The insurance company said in the lawsuit that it doesn't believe it has an ongoing obligation to defend Heard. Friday, they sued her. And then suddenly they revamp this motion and put it out to the public, leak it out to the public. Gee, do you think they were trying to cover something up? Spokesperson for Heard was not immediately available for comment Friday because they were too busy pushing out the deadline crap. An actual controversy has arisen and now exists between plaintiff on the one hand and Heard on the other hand, plaintiff being the insurance company, with regard to the duties and obligations owed between plaintiff and Heard under the policy with respect to indemnity for her actions in the Depp case, the insurance company said in its filing. The complaint lodged in U.S. District Court in California is the latest potential legal challenge for Heard. It comes a little more than a month after the verdict in the drawn-out, highly publicized trial before a jury in Virginia to decide the merits of Depp's claim that Heard had defamed him and Heard's countersuit. The trial involved weeks of contentious testimony, including Heard's graphic allegations. Depp denied Heard's allegations of abuse. In 2019, Depp brought a $50 million libel case over his ex-wife's December 2018 op-ed in Washington Post, in which Amber described herself as a public figure representing domestic abuse. The op-ed didn't mention Depp's name. We know all this. But last month, Depp won the $10 million judgment against Heard after the 6-week trial. Then Depp won 3 claims against Heard, while Heard won 1 of 3 claims she brought against Depp. Now her insurance company says it does not believe it has to pay Heard on the policy, which provided liability protection up to $1 million. The lawsuit said the insurance company had written a policy for Heard in 2019. Well, first of all, I'd love to know when that date. I mean, that's after Mr. Depp filed against her. So she was already on the hook for this case, and they issued her a policy after that. So already I think there's a problem there. Plaintiff contends it has no duty to defend her based on California insurance code. The insurance company said in the plaintiff the state code provides that an insurer is not liable for a loss caused by the willful act of the insured, the lawsuit said. The insurer said it had initially advised her it would provide a legal defense, but under California law, it did not have to provide or indemnify her for her actions. The jury's factual findings established that Heard's liability is caused by the willful acts of Heard. That was the malicious. That's when the jury found her. She did this with malice and gave punitive damages. New York Marine and Insurance Company suit said Heard plans to appeal the jury's decision in the defamation case. I'm guessing she's going to have to go back to trial for this one in California. She's going to have to, I'm not sure she's going to let it go unanswered and just, or she's going to try and fight it, but she's stuck. So this is some last minute news that's come up. I wanted to get it out there. There's a lot of our legal YouTubers covering it. Full disclosure, I watched Nate the Lawyer and I watched Emily D. Baker last night, up very late. But I also wanted to bring in some of my side as a lay person, as a potential juror, and that's why I went looking on the Jurors site. So hopefully I'm bringing a little bit of new information. It's pretty much easy to read. It's pretty basic. She gave herself out on the first one. So what do you think? Do you think he's going to be, excuse me, do you think Judge Ascarati is going to grant this? I don't see it. She's done. And again, sorry to say nothing else will be uploaded on the website, so we won't know. Meanwhile, I'm continuing my coverage on Brooks versus Depp. I've got a new video that came out yesterday and a new one coming out Monday. I've also did a weekly roundup, which I hope I have some information, interesting tidbits in there. And this came out, of course, after this information came out after I finished that one. So appreciate your support. Appreciate very much if you like, subscribe, and share. I'm a new channel, trying to stick around for a while. Let's see how it goes. And I want you all to have a great weekend. And thanks so much for showing up. Have a great day. Bye-bye.